Welcome to the tutorial course on company law. First, we will discuss Introduction to Company Law. This presentation will guide you through the essential aspects of company law. Let's start with an overview of the contents. We'll cover the basics of company law, features of a company, types of companies, non-profit associations, the role of the Securities and Exchange Commission of Pakistan, and conclude with future considerations. First, we will delve into an overview of company law, providing a foundational understanding of its principles and significance. Definition of company. A company is defined as an organization formed to carry on a business, which is registered under applicable corporate law. This includes public and private entities with a distinct legal identity separate from their owners, allowing them to engage in legal contracts and hold assets in their own name. Features of company law. Company law encompasses the rules and regulations governing the formation, operation, and dissolution of companies. Key features include limited liability, separation of ownership and management, and legal protections for shareholders, ensuring corporate compliance and governance. Importance in business. Understanding company law is crucial as it provides a framework for business operations, protecting the interests of shareholders, creditors, and the public. It promotes transparency and accountability while enabling businesses to thrive in a regulated environment. Companies Act 2017. The Companies Act 2017 serves as the primary legal framework that governs the establishment and regulation of companies in Pakistan. It outlines the rights and responsibilities of companies, directors, and shareholders, facilitating smooth corporate operations. Role of SECP. The Securities and Exchange Commission of Pakistan, SECP, plays a pivotal role in the enforcement of company law. It oversees company registrations, compliance with regulations, and protects investors by ensuring transparency in corporate practices. Regulations governing companies. Various regulations under the Companies Act, including those related to corporate governance, financial reporting, and shareholder rights, ensure that companies operate fairly and transparently, thereby boosting investor confidence and market stability. Next, we will explore the features of a company, highlighting its distinct characteristics and legal identity. We will compare companies with sole traders and partnerships, focusing on liability, financial risk, and legal protections. Sole traders. Sole traders operate independently and are personally liable for all business debts, unlike companies which limit liability to the amount invested. This exposes sole traders to significant personal financial risk compared to the limited liability structure of companies. Partnerships. In partnerships, each partner is jointly liable for business debts, presenting similar risks to sole traders. However, compared to companies, partnerships lack separate legal personality and corporate protections under the law. Companies limited by shares. Companies limited by shares allow shareholders to invest in a business while limiting their liability to their shareholding amount. This structure differentiates them from sole traders and partnerships by providing a safety net against personal financial losses. A company has a separate legal personality, meaning it can own property, incur debts, and enter contracts independently of its shareholders, providing significant business advantages. Definition of corporate personality. Corporate personality refers to the legal concept that a company exists independently of its shareholders, allowing it to enter contracts, own property, and incur debts as an entity distinct from its owners. This principle is fundamental to corporate law. Rights and obligations. Companies possess the same legal rights and obligations as natural persons, enabling them to sue and be sued, hold property, and engage in business activities. This confers significant advantages in business operations. Implications for shareholders. Shareholders are shielded from personal liability for company debts due to the separate legal personality of the company. Their financial risk is generally limited to their investment in shares, enhancing attractiveness for potential investors. Now, let's look at the different types of companies, each with unique structures and purposes. Companies can be classified as limited by shares, limited by guarantee, or unlimited, each with specific financial and operational implications. Companies limited by shares. In companies limited by shares, liability for debts is restricted to unpaid shares held by shareholders. This structure encourages investment while protecting investors from additional personal liabilities beyond their capital contributions. Companies limited by guarantee. Companies limited by guarantee have members who guarantee a specific amount to be paid in the event of the company's winding up. These businesses may not issue shares but are often used for non-profit organizations, providing a framework for liability limitation. Unlimited companies. Unlimited companies have no limits on the liability of their members, meaning that owners can be personally liable for business debts without a cap. This form might be attractive in certain industries but poses higher financial risks to investors. We will distinguish between public and private companies, examining their governance structures, regulatory obligations, and shareholder engagement. Private companies. Single and multiple members. Private companies can have single or multiple members, with specific rules governing their formation and operation. Single-member companies, SMCs, streamline operations, while multiple-member firms require more rigorous governance structures. Holding and subsidiary companies. A holding company owns a controlling interest in another company, subsidiary, impacting corporate governance and strategy. This relationship allows for consolidated financial statements and strategic alignment in business operations. Public companies. Listed and unlisted, public companies offer shares to the general public, thus having more regulatory obligations. Listed companies trade on stock exchanges, enhancing liquidity, while unlisted companies do not offer their shares publicly, affecting capital-raising strategies. Moving on, we will discuss non-profit associations, their purpose, and how they operate within the legal framework. Non-profit associations aim to benefit the public, engaging in various activities while enjoying certain legal protections and adhering to specific regulations. What is an association not-for-profit? An association not-for-profit operates primarily for purposes of public benefit rather than profit generation. These organizations focus on social, educational, or charitable activities while enjoying some liability protections under corporate law. Scope of activities. Non-profit associations can engage in various activities such as charity, education, and social welfare, provided these are not in conflict with national interests or laws. This flexibility allows them to address significant societal needs efficiently. Conditions for registration. To be recognized as a non-profit association, organizations must meet specific criteria set forth by the SECP, including demonstrating a commitment to public service and adhering to the regulations pertaining to such entities. Non-profit associations must obtain licensing from SECP, adhere to operational regulations, and are restricted from profit distribution, ensuring accountability and compliance. Licensing by SECP. Non-profit associations must obtain licensing from the SECP to operate legally as limited liability entities, allowing them certain privileges while ensuring they adhere to operational regulations for accountability. Prohibited activities. Non-profit organizations are restricted from distributing dividends to members and engaging in activities that violate public interest or national policies. These prohibitions aim to maintain the integrity of the non-profit sector. Obligations as a limited company. Non-profit associations, once registered, are subject to statutory obligations similar to those of profit-seeking enterprises, ensuring transparency, accountability, and compliance with corporate governance standards. Next, we will examine the role of the Securities and Exchange Commission of Pakistan in regulating and overseeing corporate governance. The SECP enforces corporate governance, facilitates fair market practices, and protects investors' interests. It operates through a head office in Islamabad and regional offices across Pakistan. Role and functions. The SECP regulates and oversees corporate governance, facilitating fair market practices and protecting investors' interests. It ensures compliance with the Companies Act, providing mechanisms for dispute resolution and corporate inspections. Structure and organization. The SECP consists of a head office in Islamabad, along with several regional offices. This structure enables effective oversight across Pakistan and streamlined processes for company registration and compliance checks. Powers under the Companies Act 2017. The SECP has broad powers under the Companies Act 2017 to enforce compliance, conduct investigations, and impose penalties for violations. This authority is crucial for maintaining orderly market practices and corporate responsibility. Registrars ensure accurate company registration, maintain corporate records, and enforce compliance through inspections and regulatory actions. Registration processes. Registrars are responsible for the registration of companies and ensuring that all required documentation is accurately submitted. This role ensures that companies meet legal requirements and helps maintain an organized corporate registry. Maintaining corporate records. The registrar maintains comprehensive corporate records, including documentation related to company formation, changes in structure, and compliance filings. This record-keeping is essential for transparency and regulatory adherence. Enforcement and inspections. Registrars have the authority to conduct inspections and enforce compliance with company laws. They can assess corporate records, seek explanations from directors, and ensure that companies adhere to regulatory obligations. In conclusion, we will summarize key points and discuss future trends and considerations in company law. Key points include the importance of corporate structure, legal protections for investors, and regulatory compliance, all contributing to a robust economic environment. Importance of corporate structure. Understanding the importance of corporate structure enhances business operational efficiency, provides legal protections, and fosters investor confidence in the market, contributing to a robust economic environment. Legal protections for investors. Legal frameworks exist to safeguard investors' interests by limiting liability and enforcing accountability among company directors and managers, thereby promoting stability and trust in the corporate sector. Regulatory compliance. Adhering to regulatory obligations ensures that companies operate within legal boundaries, minimizing risks associated with legal disputes and enhancing corporate governance. Future trends in company law include the impact of technology, evolving regulatory standards, and the globalization of business law, necessitating continuous adaptation and innovation. Impact of technology. The evolution of technology is reshaping company law, leading to greater emphasis on digital compliance, cybersecurity regulations, and the impact of fintech innovations on traditional corporate structures. Evolving regulatory standards. As business practices develop, regulatory standards evolve to address new challenges and risks, necessitating continuous adaptation by companies to maintain compliance alongside innovation. Globalization of business law. The globalization of business necessitates an understanding of international regulatory environments, as law crosses borders and companies engage in cross-border transactions, demanding more cohesive regulatory frameworks. Thank you for your attention. We hope this presentation has provided valuable insights into company law.